acceptance. In the previous podcast, I spoke about the first of the 6 requirements for a binding contract, that of an offer. As you will recall, an offer is a statement that a party is willing to enter into an agreement on specific terms, on the basis that if those terms are accepted, the result is a binding contract. In these podcasts, this and the next one, I will discuss the law around the second aspect, the acceptance, and how someone can accept an offer. What is acceptance? Acceptance at law is an unqualified, unconditional expression of a commitment to all the terms proposed by the offeror, and this expression must be communicated to the offeror and made with the intention of accepting the offer. There is quite a lot to unpick here, so there will be 2 podcasts on acceptance. In this first one, I will focus on the requirement that acceptance is unqualified. An acceptance must be unqualified, by which we mean that it must be accepting of all the terms proposed by the offeror. Action which is an attempt to modify the terms, for example, by looking to agree to only some of the terms, is not acceptance, and, indeed, it destroys the original offer, such that it is no longer capable of acceptance. Conversely, asking a question as to whether an offeror might be willing to vary the terms of their offer is not treated as destroying the original offer, such that it is still open for acceptance. The distinction, which is not always an easy one to apply in real life, comes from 2 cases. The first is the case of Hyde and Wrench. This is a case about the sale of a farm, which Wrench offered to sell to Hyde for £1,000. Hyde replied, offering £950, which Wrench rejected. Hyde then attempted to accept Wrench's original offer of £1,000 and sought what is known as specific performance of the contract, an order from a court that Wrench must sell the farm to Hyde for £1,000 in fulfilment of Wrench's contractual obligation. Did Hyde accept Wrench's offer without qualification? The court held that no, Hyde did not. Rather than accepting Wrench's offer, Hyde had made a counter-offer of a new price. This was an offer which Wrench was capable of accepting. More importantly, in making such an offer, Hyde's counter-offer had destroyed the original offer of Wrench, such that it was no longer capable of being accepted. By offering £950, Wrench's offer of £1,000 fell away, so there was nothing for Hyde to accept. Think about the circumstances here. Wrench says, "I'll sell this to you for £1,000. You reply, "I'll offer you £950. I say, "No thanks." Should you still be able to say, "Okay, I'll take it for £1,000, and that this is a statement of acceptance, forming a contract?" Of course, it was open to Wrench to say, "No thank you, it is £1,000, which would likely to have meant that a new offer of £1,000 was created, capable of acceptance. But in the absence of the creation of a new offer by Wrench, Hyde's counter-offer of £950 destroyed the original offer. And because Hyde's offer of £950 was an offer, Wrench could have accepted it had he wanted to do so, thereby creating a binding contract. But what if Hyde's counter-offer of £950 had been phrased more as a question? The case of Stevenson dealt with an offer to sell iron, which the defendant made to the claimant. The claimant asked whether the defendant would accept a slight change to the terms of the offer, delivery over a longer period of time, for the same money, or, if not, the longest period which the defendant was willing to give. The defendant did not reply and, instead, sold the iron to a third party. The claimant, who did not know of this sale, telegraphed the seller and indicated their acceptance of the offer on the original terms. Of course, the seller had already sold the iron to someone else by that point. The claimant brought the case, arguing that, having accepted the seller's offer, there was a contract, which the seller, the defendant, had breached, since it could no longer sell the iron since they'd sold it to someone else. The court in this case distinguished Hyde and Wrench, holding that the claimant had asked a question seeking more information, which was not the same as a counter-offer. As such, it did not destroy the original offer, which remained open to be accepted. As I will discuss in a subsequent podcast, there are rules around the revocation of an offer, and one of the rules is that revocation must be communicated for it to be effective. Since, in this case, the seller's communication of the revocation, that he had sold the iron to someone else, did not arrive with the would-be buyer at the point at which they indicated acceptance, the court held that there had been no revocation of the offer, and, as such, there was an offer capable of acceptance, and that, indeed, the claimant had accepted the offer. You will want to read the cases to understand these points in detail, but the gist of the distinction is that in Hyde and Wrench, Hyde's offer of $950 rather than $1,000 was treated as a counter-offer, which destroyed the original offer, whereas in Stevenson, the claimant's communication about a different term was considered a question and not a counter-offer, meaning that the original offer stayed intact. Does this really mean that there is a distinction in law between a statement of, "I offer $950 instead of $1,000, and the question, "Would you take $950 instead of $1,000? On the one hand, this seems to be a very slight difference of words to have such a fundamentally different interpretation of a matter of law, and that someone who casually picks one form of words over another may, unwittingly, change their legal environment materially. On the other hand, if someone is genuinely trying to explore the parameters of a deal, for example, asking whether something is included or whether there is scope for variation, would it be right if their question were to be treated as an offer, which the seller was capable of accepting? This would lead to the risk that someone who is merely expressing an interest and who wanted to know more found that they had entered into a binding contract. Something for you to ponder on as a matter of academic thought, and in practice, it suggests a need to be very clear in your communications. So far, the discussion has been limited to the situation where there has been, if I can put it this way, an active conversation between the parties or potential parties to a contract, a meaningful, intended dialogue. A second situation to consider in the context of unqualified acceptance is what is known as Battle of the Forms. This is the situation in which each party puts forward documents which purport to conclude an agreement based on their own standard terms. For example, you send me an email offering to sell me 10 widgets for £10 on your standard terms. I reply saying that I accept your offer to sell me 10 widgets for £10, but on my standard terms, and I transfer £10 to your bank account. You send me 10 widgets with a note saying thank you for your payment of £10, here are your widgets, my standard terms apply. Do your terms govern the contract, or mine? The leading case on this Battle of the Forms situation is Butler and Corp, which I encourage you to read. In this case, Butler offered to sell a machine tool to Corp on Butler's standard terms. Corp replied, saying that they were happy to buy the tool on their own standard terms. They did this on their own paper, which had a detachable segment at the bottom, clearly stating that their own terms applied to the order. Butler ripped off this segment and completed it, and sent a letter back to Corp saying that the order was subject to their, Butler's, terms. There was a dispute over price, and the case went to court, with an argument as to whose terms applied. The court held that Butler had made the original offer. Corp, in sending a letter about their standard terms, had created a counter-offer, destroying Butler's original offer. In completing and sending back Corp's tear-off slip, Butler had accepted Corp's offer and was bound by Corp's terms. The letter from Butler to Corp, which accompanied the tear-off slip, was simply correspondence about the order and not a counter-offer. As you can see, this does not lead to two very clear situations. Think back to my email example. Whose terms apply? You could argue that your terms apply, since I clearly said, I accept your offer, and sent you the sum of money that you were asking. Or you could argue that my terms apply, since I clearly made a counter-offer by stating that my terms apply, which you accepted when you accepted my money and sent my widgets. Although, as we discussed earlier, a written document signed by both parties is not necessary for most contracts, it might be pertinent to have such document to avoid this kind of argument later. You may also want to be very careful about checking whether someone's correspondence, for example, the small print of an email, purports to include their terms, and, if it does, being very clear in replying, saying that we do not accept that your terms apply. I have included in the accompanying materials reference to a number of other cases on this battle of the forms situation, and I would suggest that you read and consider these. As I said at the very beginning, for an acceptance to create a binding contract, it must be unqualified, unconditional, and communicated back to the offeror. The situations which we have explored here, the ideas of counteroffer, of asking questions, or for more information, and the battle of the forms, all go to the first point as to whether the acceptance has been unqualified, or whether, in fact, a counteroffer has been created, which has destroyed the terms of the original offer. In the next podcast, I will discuss the other two criteria, that acceptance must be unconditional, and that it must be communicated to the offeror.